Our second speaker for today is Peter Cuthbert-Low. He is the past president of the Singapore Law Society and is a litigation lawyer. His areas of practice includes defamation law. Over the years, he has represented clients in high-profile defamation lawsuits, including those taken out by Lee Kuan Yew, Lee Hsien Loong, and other PAP leaders against defendants such as the Far Eastern Economic Review and opposition politicians Tang Leng Hong and Dr. Chee Soon Juan. He was also appointed counsel of the Law Society's prosecution of blogger Gopalan Nair for posting inappropriate statements concerning the judiciary. Peter is a founding member of the human rights NGO Marua and speaks today as a representative of Marua. Peter.
Okay, good afternoon. What I'm going to speak about is law of defamation. I'm going to share with you some of ideas which I've gotten from the case which I handled, and this is the case of Dow Jones publication Far Eastern Economic Review, sued by LKY and PM. My presentation will be done against the backlog or backdrop of other perils or pitfalls when we deal with the issue of free speech. I will not cover content, for example, so I'll just only focus on defamation law. But nonetheless, it is within that backdrop. Okay. Now, why I chose this case is this. I think as of now, it contains the most authoritative statement on law on defamation as it relates to media. The case after the case was decided, I don't remember any other. It was decided by Court of Appeal. I don't think I come from any other judge who has expressed any views about one of the defenses raised in this case. And in that sense, it is important. Now, this case, I think I handled it from between 2007 to 2009, and maybe 2010. And the backdrop to this case is this. Number one, there's a history of political defamation suits, and number two, there's a history of disciplinary damages awarded against defendants. And you see that I just choose one example, okay, one personality, and you can see that Mr. Lee has sued in a period of 40 years, starting from 1965. That was 2 years after free speech was embedded in our constitution. From 1965 to I think present, there have been at least 20 over lawsuits involving Mr. Lee, especially Mr. Lee. Okay. 20 lawsuits, and 20 lawsuits, and half of them concerns political opponents. The other half concerns foreign publications, whether it's Fear, Bloomberg, Economist, IHT. Yeah. So that is a backdrop to this lawsuit. Other backdrop is this. Okay. Crippling damages awarded against defendants. This is the one extraordinary example. A former client of mine also. And I think you all know him, right? Tang Leng Hong, right? And he was sued by, I think, half the cabinet. And then he was MMLKY, PM Goh Chok Tong, DPMs Lee Hsien Loong, Tony Tan, and then ministers Lee Yock Suan, Teo Chee Hean, and I think contained for three then current MPs and three then retired MPs. So this was the backdrop when the case came up. Now essentially the case arose because in the July and August issue of Fear, the hard copy issue, there was an interview published by concerning T. Soon Juan. And in that article, T. Soon Juan talked about the NTF saga, you recall, the NTF saga. And NTF was branded as an organization which is symbolizes financial impropriety, secret dealings by the CEO. So in that article, there was mentioned that the way the Singapore government was run was also, quite close. It was in the same way as NTF. So the article associated the two organizations. And sorry, just mention. Yeah, the article appeared in the hard copy of Fear. It was also appeared in the Fear's website, and it was also republished in 12 or more websites. So the complaint of then was that the article said it was unfit for office because he was corrupt, and number two, he suppressed those who questioned him because he was afraid that they might expose his corruption. Same allegation was made against PM, and there was also another allegation say that PM shouldn't have put MME inside his cabinet. Of course, Fear's defense was that, look, we didn't mean to say that MM and PM were corrupt, and there was no such imputation. And they raised three defenses, all of which were wiped out when the learned judge, High Court judge, said that, well, actually the words mean that PM and MM were corrupt, and that they used defamation laws to suppress those who question them, and all defenses were wiped. It was affirmed in the Court of Appeal. But
just the lady.
Court of Appeal, yeah, this is just a lady judge, this is Prakash. And the damages were settled. We didn't go to court to find out the amount, and it was settled at this amount because this is a low amount. Because in the case of defamation, the amount of defamation is dependent on the extent of publication. So if you take a time case, it makes a press statement, and it goes to the Straits Times daily readership got 500,000, so it's that much more. Whereas in the case of Fear, they were restricted. They only produced 5,000 copies. So that's why the amount which was negotiated was much less than in other cases. Okay. What is important about this case, as far as lawyers are concerned, okay, is that for as regards defamation, there's always this competing interest. One, to protect reputation of people, right? We don't want people to be wicked things to be said about people. So the court must protect people's reputation. On the other hand, there's also that public interest, free speech, greater political space, greater discussion, transparency, and openness. So there's this competing interest which the courts must handle. And for 100 years in the UK defamation law and Singapore law, for 100 years until 1998, the weight of law was weighted in favor of protection of reputation. Until 1998, the Court of Appeal in England and the decision was confirmed in a record by the House of Law in 2001, they said no. Okay? There are in certain circumstances, people should be allowed to make even defamatory statements if those statements are in the public interest, because the public is entitled to receive them, and the media is under a duty to communicate the information. Okay? So that was a change in the legal environment in UK, 1998. And that case arose from a decision involving another Prime Minister from Ireland, and his complaint was that the Sunday Times of Ireland, I think, alleged that he had deliberately and dishonestly misled the Irish House of Representatives and his cabinet colleagues in relation to his to the circumstances on which he resigned. Reynolds was the Prime Minister of a coalition government. He resigned, and Sunday Times carried an article about him saying that he deliberately and dishonestly misled the Irish House of Representatives. When the case went up to court, it went up all the way up to the Court of Appeal. There was a paradigm shift, and for once, the British court said, "Look, I think we should give greater weight in this modern world. We should give greater weight to political discussion. We should clamp down and protect the reputation of public personalities." Now, this they offer a sort of defense. Sometimes it's called the Reynolds privilege, or sometimes it's called the defense of responsible journalism. But whether the defense can avail a defendant depends on 10 factors. Concerning these 10 factors: the seriousness of the allegation, and then the nature and information and the extent to which the subject matter is of public concern, the source of information, steps taken to verify the information, status of the information, urgency of the matter, whether comment was sought from the plaintiff. And this is important because to be fair, okay, you want to impart, you want to communicate information to the public, but also you want to be fair to the potential plaintiff. You got to listen to him, to see his point of view, see whether he's got anything to say, and try and verify information from him. So these are the things that you have to do before the court will say, well, maybe you are entitled to the defense or responsibility. What happened in UK at that time was not isolated. Because 1 year earlier, in Australia, another Prime Minister sued the ABC, and this is Longy, David Longy, the then New Zealand Prime Minister, who sued ABC for saying that he was unfit to hold public office. And then again, in that particular situation, at that time, 1997, 1 year before Reynolds was decided, the Australian court said, look, if there is a publication concerning government and political matters, then there should be greater leeway given. Okay? You shouldn't wait, the law shouldn't wait in favor of protection of a person's reputation. And provided you satisfy these four conditions, there is protection afforded to the media, including those who broadcast information via the internet. 1 year later, the similar development happened in New Zealand. Again, David Longy, this time he sued Atkinson because Atkinson alleged that he was a dishonest and lazy and insincere and irresponsible politician. Okay? And the court said that there may be proper interest exists in statements made of actions and qualities of those currently or formerly elected to Parliament and those with limited expressions in such office so far as those actions and policies directly affect the capacity to meet their public responsibilities. So, and the defense, this a similar defense was made available in New Zealand around that time, and it spread, okay, from Reynolds in UK to Longy in Australia and New Zealand. We went over the other Commonwealth countries. Okay, you will see 8 countries listed there except Singapore, and that was why Dow Jones brought the fear case to a court of appeal, and that was why we tried to argue that this should be maybe Singapore court should take a different stance, because ever since, as I told you, ever since the constitution was free speech became embedded in the constitution in 1963, we have had this Gavin law which favors plaintiff, which favors protection of reputation. So the importance of the Dow Jones case is that there was an opportunity given to the court of appeal to ask them, look, can you consider maybe we should have this defense in Singapore available so that we have greater political space? But the answer is no, because as Jack pointed out, Article 14 does not cover citizens. It only covers, it doesn't cover, it covers only, protect only citizens, but not non-citizens. So we have this, so we are at this situation where, as far as we are concerned, as far as Singapore is concerned, defamation law still favors protection of a person's reputation. And as far as the hierarchy of court is concerned, there is a decision, and that decision is in the SDP case where Justice Linda Ang said Reynolds don't apply. This privilege does not apply in Singapore. But however, the court clearly said that okay, it was not a live issue before us, because Dow Jones, unfortunately, Dow Jones is not a Singapore citizen, therefore it doesn't apply. But the court of appeal said, look, this matter will surely come before the court, and I've been waiting for 3 years, and no media has sued as per this stuff. However, the court of appeal did say that if you had made, if you are a part of such a media, you may have exercise some degree of care, then it may be that your damages will be reduced of a person's reputation. And provided you satisfy these 4 conditions, there is protection afforded to the media, including those who broadcast information via the internet. 1 year later, the similar development happened in New Zealand. Again, David Longy, this time he sued Atkinson, because Atkinson alleged that he was a dishonest and lazy and insincere and irresponsible politician. Okay. And the court said that there may be 3 proper interest exists in statements made about actions and qualities of those currently or formerly elected to Parliament and those with immediate expression to such office so far as those actions and qualities directly affect their capacity to meet their public responsibilities. So, and the defense, this is a similar defense was made available in New Zealand around that time, and it spread, okay, from Reynolds in UK to Longy in Australia and New Zealand. We went over the other Commonwealth countries. Okay, you will see 8 countries listed there except Singapore, and that was why Dow Jones brought the fear case to a court of appeal, and that was why we tried to argue that this should be, maybe Singapore court should take a different stance, because ever since, as I told you, ever since the constitution was, free speech became embedded in the constitution in 1963, we have had we have got this defamation law which favors plaintiff, which favors protection of reputation. So the importance of the Dow Jones case is that there was an opportunity given to our Court of Appeal to ask them, look, can you consider maybe we should have this defense in Singapore available so that you can have greater political space? But the answer is no, because as Jack has pointed out, Article 14 does not cover citizens. It only covers, it doesn't cover, it covers only, protects only citizens, but not non-citizens. Okay. So we have this, so we are at this situation where, as far as you are concerned, as far as Singapore law is concerned, defamation law still favors protection of a person's reputation. And as far as the hierarchy of court is concerned, there is a decision, and that decision is in the SDP case where Justice Belinda Ang said Reynolds don't apply. This privilege does not apply in Singapore. But however, the Court of Appeal did say that it was not a live issue before us, because the Dow Jones, unfortunately, Dow Jones is not a Singapore citizen, therefore it doesn't apply. But the Court of Appeal said, look, this matter will surely come before the court. And I've been waiting for 3 years, and no media has brought this matter up. However, the Court of Appeal did say that if you had made, if you are a part of the side of the media, you may have made exercise some degree of care, then it may be that your damages will be reduced. So where do we stand now? The complaint raised by lawyers in the court in the last 15 years, I think, has been that our defamation law has a chilling effect on greater political space. That is the effect. And these are the perils. Okay. For Mr. Tang Yang Hong, he's now a fugitive. He's got a problem with the tax department, and because he's a lawyer, he was referred to Law Society in the course of defending himself, and he was made a bankrupt. So these are the perils of if you venture into the public arena. Okay. After the last elections, I think for once, I think things were a bit. We didn't get any defamation suits, although there were threats, I believe, but there were no defamation suits. With that, I conclude my presentation. Thank you.